Startups are difficult, and especially in the beginning, you really don't know who to trust and what things are essential to make sure that your business isn't going to fail, and what things are just scams. And sadly, there are a lot of folks out there who are straight up looking to scam you, and other people, they may mean well, but it's what they're offering, it's more of a benefit to them than it is to you. And I see this all the time in what I do. There's a lot of stuff relates to patents, it relates to inventions. And so what I want to give you with this list is the top 5 invention and patent scams. So if you're new to the channel, my name is Dylan Adams. I am a patent attorney and author of the best-selling book, Patents Demystified, which is a book that is used worldwide, including top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC's hit show, The Profit, with Marcus Lemonis. In my patent practice as a patent attorney, I work with clients of all sizes, from Fortune 100 companies to startups to Shark Tank companies, and this channel gives you a lot of the insider tips and secrets on how I help these clients succeed. So be sure to subscribe for more great startup and patent content. So let's go ahead and get into that list. So number 5 is infringement analysis. Now, what do I mean by infringement? Because people kind of get this term mixed up when it comes to patents. So by infringement, I mean do you have a product or are you offering a service that infringes the patent of somebody else? Okay, so this is not, is there prior art that wouldn't allow your product to be patentable? This is, are you infringing on somebody else's patent? And one of the things about infringement is you have to have a product that is infringing. You have to actually be doing a method that infringes, like producing things with a patented method. So that's what infringement is. And now there's a natural tendency. Hey, you have a startup and you have a product. I want to know, hey, am I infringing on anyone else's patent? I want to be a good citizen of the business world. I don't want to willfully infringe on other people's patents. And you would think that, hey, there's going to be some good way that I can go out, I can do a search, and I can determine, hey, I'm infringing on somebody else's patent or I'm not. That's a natural thing that startups want to be able to do, and I get that question all the time. Unfortunately, doing an infringement analysis is extremely difficult, and especially to do one well. I mean, no joke, having a patent attorney do a legit search and do an analysis is going to be in the probably tens of thousands of dollars. Doing a good job on an infringement search is a really expensive thing to do. That being said, there are a lot of companies who are going to try to act like, oh yeah, we can do the search and we can, we're going to figure this out. If it's going to be something that's going to be cheap, you're going to probably be scammed. So just doing a search as far as like what issued patents are out there, that's only half of it. You have to compare that to exactly what your product is, compare it to the claims of the patent. That is time consuming and difficult to do. And that's an unfortunate thing that I think that frustrates a lot of people is, like I said, they want to be good citizens of the community, of the business community. They don't want to willfully infringe on people's patents. They don't want to cause problems. They want to, stay in their lane typically. But the way the patent system works, unfortunately, is it is difficult, if not impossible, to do that sort of analysis for a lot of different reasons. One, just the basic one is, so by default, patent applications are held in secret for 18 months. So you may not know about patents that may be pending, that may be very relevant to what you're doing, that you may infringe on later on. And there's also the option to potentially keep a patent application secret all the way up until it issues. So there may be pending patent applications that may be completely relevant to what you're doing that you may later infringe that are completely secret to you. There's also the issue of people want to do these infringement analyses when they don't have a full understanding of what the product is. And there's kind of a cart before the horse thing. A good infringement analysis, it's all about the exact details of what your product is. It's not going to be a general idea that's going to be infringing. It's going to be one specific way of doing that. And what I'll tell you is that, one little change in a product, that can be all the difference between infringing or non-infringing. And so it's kind of unfortunate that you can't just do this general search up front. It really depends on the final specific product that you have. And here's the mistake I see people make sometimes, is that they do this analysis, or they do a general prior art search and they see, well, there's some things that are out there and I'm just not going to do my business. I'm not going to go ahead with this product. And that's unfortunate, because what I see a lot of times with startups is they start with this certain idea of how their product is going to be, but over a long period of time, it evolves and it completely changes. And what is very likely is that what ends up being their final product is not something that is infringing. It's completely different and wouldn't infringe. And their initial idea, it's something that probably wouldn't be infringing anything, but they get scared off because they see things out there that's similar, and they're scared about potentially infringing and being stopped from selling their product or getting a cease and desist letter or whatnot. But the unfortunate thing is that that's just the cost of doing business. There is inherent risk in having a company and having a product, and you have to take that risk. It's frustrating for a lot of people because they want to do the right thing, quote unquote, but it's typically prohibitive to do a good infringement analysis. So don't let companies tell you, hey, you need to do this infringement analysis. Either you need to spend tens of thousands of dollars to do it up front. Don't do that. And also, if they're going to offer you some sort of cheap version of doing some sort of infringement analysis, don't do that either. It's going to be some sort of scam. It's probably just going to be some cheap prior art search that doesn't involve any true analysis. So, talk to a patent attorney about it, as far as the benefits and the downsides of doing infringement analysis. But to be honest, very rarely does it actually make any sense. And if you do one, a lot of times it's going to be a scam. And number 4 is market analysis services. And so I see this a lot where people have a startup and they don't really know the landscape. They don't know about competitors. They don't know what other products are out there. And there's a lot of services that say, hey, we'll tell you about the market. We'll do this landscape comparison. And I've seen the things that come out of this. They look really pretty. They come in these binders. There's all these, colorful presentations of things. And it makes people feel like, yeah, all this research has been done and it says that my idea is great and it's new and it's something that, is what everybody needs. But a lot of times, the market analysis is so broad and so general and really isn't applicable to people's businesses and doesn't give them any sort of actionable information. It's like, sure, you can get percentages of, how much money these markets make a year and some general competitors. But a lot of times it ends up being just worthless stock information. And like I said, there's going to be these pretty diagrams and these pretty binders. 98% of that stuff is stock stuff that they already have, that they just, put your industry name in there, or, they have some little tiny specializations, and people can spend $5,000, $10,000, $15,000 on some analysis that seems like it's all special, but it's mostly just boilerplate stuff that's customized a little bit. When it comes to doing market analysis, I'm not saying that you shouldn't do that. But the thing is, you as the business owner should do that yourself. Don't buy your way to success. You can't do that. It doesn't really work that way. You need to do the legwork. You need to understand the competitors. You need to understand what the product landscape is. That's the work you need to be doing on your own. You don't pay somebody else to do that. And either you should be an expert in the field as it is, and if you're not right now, that is your job as the business owner, is to become that specialist. You need to understand the market in and out. You need to understand the products in and out, the competitors, all that kind of stuff. You need to fully understand that. And it doesn't help to have somebody else do that analysis for you. You need to do that work on your own. That's the value of doing it, is your own learning. Another thing is that these industries and these products, they tend to be so specialized that you need to really do an analysis of this one niche industry or this one niche product. And again, that's important for you to do it yourself. So if you see these companies saying, hey, you need to do market analysis, they're right. But if they're going to offer you some service for, few $1,000s or, tens of thousands of dollars to do this analysis for you, most likely that's actually going to be a scam. And number 3 is prior art searching. Now, when it comes to prior art searching, let me tell you what I mean by that. And this is, again, what people get confused about. They get confused by infringement versus patentability. Now, a prior art search, that is going to be an analysis to determine patentability of a process or a product that you have. So prior art comes up during the patent examination process. The examiner is going to look at your claim and say, is what you have, is it new and non-obvious over the prior art? And a lot of times that's going to be cited as issued patents or even pending patent applications that may be currently pending or may have actually gone abandoned, but really it can be any technology disclosure that's going to be prior art. It could be actual products, like products in a catalog. It could be blog posts. It could be YouTube videos. Really, any disclosure. I mean, scientific papers. White papers on products that are on people's websites. Descriptions on product websites. Really, any sort of technology disclosure technically is prior art. And so when people do a prior art search, what they mean by that is they're going to try to determine whether somebody's invention is going to be new and non-obvious and whether it's going to be patentable. Now, there are some limited cases, and I have some good videos on some of the cases where you may actually want to do a prior art search, but the vast majority of the time you don't want to do a prior art search because it's a waste of time, it's a waste of money, and you're not going to get any actionable information that is really going to be able to help you with your product. And again, it's kind of a cart before the horse thing. A lot of times you don't have enough information about your product in order to do a prior art search. But again, let me tell you why this ends up being a scam, because it preys on people's fears. There are a lot of companies say, well, you need to do a prior art search because, if your invention isn't patentable, you need to know about this up front, which again, it's a very intuitive thing. And people tell me this all the time. Before I start the patent application process, I want to know whether my invention is patentable. And I don't want to spend all the money on a patent application if it's going to be rejected. And yes, again, that is totally a rational thing to do. But unfortunately, the way the patent process works is it doesn't make any sense to do any of this prior art searching. One of the things to keep in mind is that patents are not a binary thing. It's not just about having a patent or not. Patents are it's a spectrum of protection. You can have a really broad patent that covers a lot of different things that's extremely valuable, or you could end up getting a patent. Sure, you get it issued, but it is so narrow and so specific that it's effectively worthless because anybody could design around it. So when it comes to patentability, a lot of times it's going to be somewhere in the middle, right? A lot of times you're going to be able to find a way to get a patent issued, but it's more a question of, are you going to be able to get a broad patent versus a narrow patent? And so people kind of miss the thing. It's like, well, I'm scared because, my idea, my product, is it patentable? That's usually not the question. The question is, are you going to be able to get broad or narrow protection? And a prior search, for certain products, that it can be relevant to that. But the problem is the examination process is so subjective. One examiner is going to find certain prior art and say, hey, this is totally unpatentable. I'm not going to allow this application to go through. Whereas the other examiner can say, oh yeah, well, this is similar, but I can see what you're doing. It's new and it's non-obvious over what you're actually doing. I'm going to totally grant your patent. So there's the subjectivity that, sure, you can spend all this money and all this time doing this prior art searching, but the examiner that actually gets your case is going to look at it very differently and then is going to come to their own decision. And so I see a lot of people spend all this time and effort and freak out about this prior art and do all this analysis, and it's just so subjective. In the end, a lot of times the patent examiner doesn't even use any of the prior art that they found. The patent examiner finds some other prior art. So prior art searches, aside from a few specific cases, which again, look at my video on when you might actually want a prior art search. A lot of times prior art searching is a total scam. It's a waste of your time, it's a waste of your money, it's a waste of your energy and your efforts. Focus on other things. Focus on making the best product that you have. Just file your patent application. Because again, you're not going to know whether it's going to be able to be broad protection or narrow protection until you actually get into examination, until you get the examiner in front of you. And again, a lot of prior art is held in secret by default, it's 18 months, and it could be all the way up until a patent issues. And so you're doing all this searching, and there could be completely relevant prior art out there that is impossible to find. It is literally not publicly available. And so you can do all this analysis and it's completely worthless because the most important stuff may be completely hidden to you. Okay? So also, when it comes to prior art searching, what's important, it kind of like with Infringement, it's about the details of the product you have. People want to do this general prior art search on their general idea. But when it comes to what's actually patentable, it's going to be in the details. Any broad idea probably isn't going to be patentable. It's going to be the specific implementation of that. Okay, and so that's the thing. That's why I say it's kind of cart before the horses. You know, if you try to do this prior art search when you just have a broad idea, well, yeah, there's going to be tons of prior art on that. You know, like, yeah, of course there's going to be, but it's going to take a lot of times, months, if not years, to get a prototype and to have your specific implementation and know exactly what you're going to be doing. That's when you may want to do a prior art search, or when it would actually be relevant. But at that point, you've already invested all the time and money into the product, and you know, you might as well just go ahead with it, right? So that's why prior art searching doesn't make a lot of sense, and why people who are pushing to do it and say it's a standard thing, you have to do it. No, it's not. Prior art searching, a lot of times, by and large, is a total scam. So don't waste your time, don't waste your money. And number 2 is cheap provisional patent applications. All right, so provisional patent applications are extremely powerful, and I would say a lot of times it's the default way that startups should begin the patent process. The problem with provisional patent applications is they're kind of a double-edged sword, is that, you know, used appropriately, they are great, you know, and that some people, they kind of give them bad rap because they think, oh, it's provisional, it means that they're not as good. But a good provisional patent application is typically the best way that startups should start the patent process. But the problem with provisional patent application is the patent office will literally accept anything that you file and say it's a provisional patent application. I mean, no joke, I could put a scribble on a piece of paper, file it at the USPTO, and they're going to stamp a filing date on that and say, you are patent pending on whatever the hell that scribble is, right? But does that give you any protection? Absolutely not. It gives you no protection. Now, a lot of the services, they're going to say, hey, we're going to do a provisional patent application for $100, things like LegalZoom or some of the others, you know, these other services that do these cheap provisionals, or even some attorneys who do really cheap provisionals. What they end up doing is they just, you know, take an abstract, maybe a couple of lines that you have drafted yourself, you fill out a questionnaire or something, and they file that as a provisional patent application. Absolutely, USPTO is going to slap patent pending on it, give you a filing date, give you an application number, and you can go off and tell everybody that you're patent pending. But the protection that you actually have is completely worthless. And that's the problem with a lot of these services, is they don't tell you that you only get credit for what is actually filed. And so you really should be having a full description of what the technology is. Describe it in extreme detail. Talk about all the different variations. A provisional patent application ideally should have as much detail as the non-provisional application. The main difference, though, is it doesn't need to be as formal. It doesn't need to be written in a specific way. But the big issue that I have with a lot of these companies is they try to make it out like, oh yeah, just throw in an abstract. You know, these 2 lines, this is going to give you adequate patent application protection. It absolutely does not. And these people are just, you know, churning out, out these cheap and worthless patent applications, making tons of money. And, you know, startups don't know any different. A lot of startups, you know, end up not being successful. And, you know, they just kind of scam people with these cheap and worthless provisional patent applications. So, I mean, what is the better way to do things? Is one, just understand what it is in terms of protection. Understand that you only get credit for the details you actually file. And that's why, you know, I recommend working with a patent attorney to do a patent application that is drafted by the inventor, scrubbed for minimal issues, and then filed at the USPTO. That can be done fairly inexpensively. But it's something that still needs to have the appropriate amount of detail, and that's why you want to have the attorney involved, so they can kind of give you a sense of like, hey, here's where you need to add detail, otherwise your patent application is going to be completely worthless. That's the information that is typically missing from these cheap provisional services. They're going to file whatever you give them, knowing that most people don't know the difference. And that's why cheap provisional patent applications are typically a total scam and not worth your money. And number 1 is invention submission agencies. And this is something you've probably seen on late night TV, or, you know, these kind of, you know, these commercials that say, hey, we'll submit your invention, and we have a data bank of, you know, 10,000 companies who are willing to review your idea. You know, I mean, it should be apparent by, the kind of commercials that these are and where they're placed, that these things are totally a scam. And I don't mean to say that, it's not always intentional, I mean, it's the kind of thing where, maybe 1 in 100,000, 1 in 10,000 people, maybe they'll actually get a deal through something like this. But typically, they're not going to get a deal from some sort of invention submission. The problem is that these companies are taking advantage of people's hopes and their dreams, and they're going to, quote unquote, submit these ideas when a lot of them they're worthless ideas. They're not well formed. They're not in a place where any of these companies are able or willing to do anything with them. And there's no coaching typically as far as like, okay, how are we going to actually put this into a package that a company is going to want to, actually license this, or where investors are going to be interested. And it's one of those things where people, it's kind of lazy. People think, hey, I'm going to buy my way to success. I'm going to spend $10,000, $20,000 on this invention submission, and I don't want to do any work. That's how I'm gonna make money off of my invention. Unfortunately, people need to do their own research, they need to do their own analysis, and they need to approach companies on their own. Doing this shotgun blanket approach, it typically is just a complete failure. Approaching companies needs to be targeted, and it needs to be well informed. There needs to be a good pitch about the product, and it needs to come from somebody who really understands the product, who really understands the business. Whether you're going to a company and you are looking for them to license the idea, or whether you're going to investors to give you capital so you can produce the product, or you can make the business a reality, you need to really understand the market. You need to understand the product, and it takes a lot of time. A lot of times it takes people maybe a company or two, or a product or two, before they really kind of get it. But the unfortunate thing that I see a lot of times is that the people who are kind of new to this, it's daunting. I get it. There is a lot to learn, and it's kind of scary, and you're getting a lot of this information from a lot of places. But don't be one of those people who thinks, okay, I'm just going to throw down $15,000, $20,000 to one of these submission companies and hope for the best, and that's the way that I'm going to make money. Unfortunately, you have to take the time. You have to do the research on your own. You have to be the biggest advocate for your own product or your company. Otherwise, it's really not going to work out. And like I said, these companies are taking advantage of the idea that people think, well, I'm going to pay my way to success, or, I'm not smart enough to do this research on my own. That's untrue. Anybody can learn how to do it. It may take a long time. You may have to spend months doing research on, how do I do market research, and what do companies want, and how do I pitch people stuff. You have to become an expert on those things. It's that learning process that is essential, and you can't pay your way through it. So that's why invention submission companies are typically going to be a total scam, and that's why it's number 1 on my list. I'd be really curious to hear from you down in the comments. Have you ever been approached by any of these companies? Have you ever talked to them? What was your experience like? I'd even love to hear people on the other side that, maybe you had a good experience. I'd love to hear your good experience, because to be honest, I have not heard any good experience from people with these companies. A lot of times people are disappointed, they are scammed, but if you've had a good experience, I'd like to know. And maybe you disagree. Maybe you think that these are great services, or they're essential. I mean, I've had people say, as far as the prior art searching goes, I've had people say, look, it would be malpractice to not do a prior art search before filing a patent application. You could be malpractice by doing this. And I just, I kind of laugh at those things, because honestly, especially for like the big companies that we work with, you never do a patent or prior art search. It just is not something that is done. And the people who say it is a standard thing that you have to do, a lot of times, it's people who are kind of being scammy who are saying these things. Not to say that there aren't times to actually do prior art searching, but a lot of times, like I said, total scam. But I'd like to know your opinions. People get fired up about this, especially about the infringement analysis and the prior art searching. People really disagree with those things. If you disagree with me, I'd love to know. Tell me down in the comments. But also, we've got a lot of other great content on this channel about patents and about startups and about how you can be a success and not fall victim to scams, not be a failure, how you don't have to, go through the failures in order to learn. This channel has a lot of shortcuts on how you can be a success when it comes to startups and patents. So hit that subscribe button, hit the little bell icon that gives you notifications when new videos comes out, because we'd love to notify you when the new stuff is coming out. So thanks for watching, really appreciate it. Give the video a thumbs up, help support this channel, and we will see you again in the next video.